Welcome to Employment Law This Week. I'm George Whipple. Our top story, the Supreme Court takes on class action waivers. In 2012, the NLRB ruled that class action waivers and arbitration agreements violate employees' rights under the National Labor Relations Act. The Fifth, Second, and Eighth Circuits disagreed, finding that those waivers do not violate the NLRA and are enforceable under the Federal Arbitration Act. More recently, the Seventh and Ninth Circuits sided with the NLRB on the issue. The Supreme Court will consider 3 cases in order to resolve this split, but any resolution could depend on the timing of the hearing. If the case is heard this term, before President Trump's nominee for the vacancy on the court is confirmed, it could end in a 4-4 tie. That would leave the law as it stands, and the split would continue. John Houston Pope has more.
The Supreme Court, in this term right now, has 8 justices since the death of Justice Scalia. And that breaks down politically into 4 justices who are traditionally conservative and 4 who are traditionally liberal on most issues, particularly on labor-related issues. They showed last term in a case that involved union rights that they will break down on that 4-4 and end up with a tie. Well, you have 3 cases that are being heard together, 2 of which ruled in favor of the NLRB's position, 1 of which ruled against. This was a case that was just taken in January under the rules of the Supreme Court with the amount of time that is allowed for briefing. It's unlikely this case would be briefed in time for the last argument sitting, which is at the end of April.
The Department of Labor files suit against Oracle. The DOL is accusing computer technology giant Oracle America of paying women and minorities less than their counterparts, and of discriminatory hiring practices that favor certain Asian applicants. The suit was filed after an OFCCP audit at Oracle's headquarters in California, which found violations from January 2013 to the present. The DOL is seeking a court order canceling Oracle's federal contracts and requiring relief for the affected groups. Oracle claims the suit is politically motivated. EEOC claims increased for the 2nd year in a row. The Commission has released detailed breakdowns of the 91,503 workplace discrimination charges filed in fiscal year 2016. Retaliation charges were the most common in 2016, making up 45.9% of all charges filed. This is the first year that the agency has included statistics about LGBT charges in the summary, showing the resolution of 1,650 sex discrimination charges and the recovery of $4.4 million for LGBT individuals. New regulations for highly skilled immigrant workers go into effect. The USCIS and the DHS have published a final rule that makes it easier to sponsor and retain skilled workers. The rule gives added job flexibility and protection to foreign workers in H1B status or in the process of applying for a green card, and adds grace periods for certain skilled workers to remain in the country while between jobs. It also expands the eligibility of certain employers for H1B cap exemptions, and clarifies how hospitals and other healthcare organizations can benefit from these provisions. And that brings us to our tip of the week. Hakeem Berry, Chief Human Resources Officer for the Northeast region of Tenet Healthcare, is here with some advice on the impact of social technology in the healthcare workplace.
Employers are tackling new challenges as social media is adopted by larger portions of the workforce. Social technology can have unintended consequences, especially for healthcare companies required to comply with patient privacy and ethics rules. Here are some steps your organization should consider to balance employee speech and privacy. Incorporate presentations on the appropriate use of social media in the workplace into your annual training program. Use off-cycle refresher courses to ensure employees receive in-depth training beyond the annual information that is often filled with many other competencies. When an event occurs, use educational workshops to have a dialogue with the department or team involved rather than simply reprimanding an individual.
Thanks, Hakeem. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.